Take roll. Jackie Cooper. Richard Davila.
Here.
Gary Hahn.
Here.
Amy Trost. T.J. McDowell. Deetra Stewart. James Fowler. Lance Brooks.
Here.
Myself. Okay, we do not have a quorum. Okay, so, with no quorum, we will not approve the minutes from last meeting. We'll move to public comment. Anybody sign up for public comment? No? Okay, we'll move to item E, staff reports. We'll first hear from Licensing Division.
Good morning, Advisory Board members. My name is Leonard Rivas with the Licensing Division. You have the licensing report in front of you with fiscal years 2018, 2019, and what we've processed so far for the fiscal year 2020 for the first quarter. The current population for the hearing fitters and dispensers is 656. Apprentice permits, 54, and temporary training permits, 130. Do you have any questions about the report?
Question? No?
I do have a few staff updates. I didn't get it on the agenda because the report was already submitted. Most of you know Vicki Watson retired December 31st. And so congratulations to Vicki on her retirement. And we hired a new staff member, Steve Ledesma. He comes to us from the Department of Agriculture. That concludes my report. Do you have any questions?
No questions?
All right, thank you.
Very much. All right, we're now here from Customer Service Division.
Good morning, Advisory Board members. My name is Tuan Nguyen. I'm the Customer Service Manager for this program. Since the last time we met, we have a very stable amount of contacts of roughly 200 contacts a month. A bulk of our requests have been assistance on the website and a little bit less on license status questions or renewals questions. Other than that, I'll be happy to answer any questions y'all have for me.
Questions?
Yeah.
Thank you. Okay, we're here now from Enforcement Division.
Good morning, gentlemen. My name is Karen Cox. I'm Senior Prosecutor assigned to this program from the Enforcement Division. Since your last meeting, we've had a couple of cases in this program. On March 22nd, 2019, a commission order was entered against a respondent, resulting in the revocation of his fitter and dispenser license based on his conviction for aggregate theft over $100,000 by a government contractor. We also issued a letter to Robert Clayton Bear, hearing aid fitter licensee, noting that his license had been revoked by operation of law, that is, revoked automatically without formal action because he was incarcerated in federal prison after a felony conviction on February 11th, 2019. In fiscal year 2019 key statistics, this is the fiscal year that ended August 31st. We opened 18 cases in this program, resolved 24. There were 2 final orders with no penalties and assessed or collected. And our statistics for fiscal year 2018, we opened 27 cases, resolved 32, and we had 1 final order again for no penalties assessed or collected. May I answer any questions?
I want to say thank you for sending the information about the cases that were opened after the last meeting. That was helpful to kind of look at the trends on that. It really looks like more unethical, unprofessional as opposed to the trial period or anything else. Is that still the case?
I would have to check on the statistics for the current ones. So,
Do you see any trends with that we should be educating our members on?
I
in some
haven't,
professional associations?
yeah, I haven't looked at the statistics for 2020 on that information, so I wouldn't be able to offer an opinion.
Any other question? Okay, thank you. Okay, now we'll hear from Education and Examination Division.
Good morning. I'm Fanny Pringle with the Education and Examination Division. To start off, we have some recent personnel updates. As TDLR has grown, E&E has restructured our organization to better accommodate.
Fanny,
Fanny.
I'm sorry, this is Wendy Pello, Assistant General Counsel. I'm sorry to interrupt. We need to stick to the agenda and the items that are noticed on the agenda for education examination. You have statistics and trends. So sorry to cut you off.
That's okay. That's all right. Statistics and trends. I believe you have our statistic report in front of you. Our next scheduled examination date is scheduled for this Saturday, January 25th, and our examination dates through May of 2021 are posted in our candidate information bulletin and linked on our website. For our practical examination statistics, we've included quarterly statistics on the pass rates. The fiscal year pass rates are also on our website. Are there any questions regarding that information? Okay, thank
Any
you.
question? Thank you.
I had a quick question,
Mhm.
if you don't mind. As we do the psychometric change that's coming, do we anticipate the pass rates will change?
Psychometric, as we do the, I'm
As we
sorry.
change the rules as far as the percentage, we remove the percentage and say it's going to be a psychometric rating, do we anticipate that'll change the pass rates?
I'm not sure what you mean by psychometric rating. We do use psychometrics to develop the examinations. Every examination question that we have is coded and rated by the subject matter experts that develop the exam, so that so that when we create the for the practical exam, when we create the tasks and the performance standards for each tasks, we do
Validation.
exactly. We do have validation through our SMEs. When we meet again as an examination review committee, we may do some further development to automate more of it. Right now, a lot of it, because of the nature of the exam itself, a lot of it is manually calculated. But yes,
It was probably a pretty worded question on my part.
That's okay.
I thought we were changing the rule to, instead of a 70% pass rate, to where it was just going to be a departmental psychometric evaluation. And so I thought that would potentially change the pass rates with that.
our subject matter experts make a determination of what the pass rate is. They've always had control over that. The way it's designed, currently, there's a point scale, and right now, like I don't have the information in front of me, but say if there's 1,000 points on the exam, then 700 points would give you a passing score, but it's up to the SMEs to make a determination if they want to raise that to 800 or lower it to 600, or however they determine what the benchmark for competency is.
David Gonzalez, TDLR, and it is recommendations from the SMEs because the agency is ultimately responsible for the advisory board giving us input on these things. The standard has been 70% for most of our exams, but it can fluctuate depending on the input that we receive from the subject matter experts and the industry needs.
Thank you.
Is there anything else?
Any other questions? Okay,
Thanks.
thank you. All right, now we'll hear from Regulatory Program Management Division.
Good morning, advisory board members. I'm Katie Bryce with Medical and Health Professions of Regulatory Program Management Division, and I'll be giving the staff report. Steve Eaker is my backup, and he's up here to assist if there are any questions on certain sections of the report. Under hearing instrument fitters and dispensers program activities, we have been working with bill implementation teams to incorporate recent legislation into program rules. We've also provided an analysis of Senate Bill 1264 on balanced billing in your meeting packet. Senate Bill 1264 protects consumers from surprise medical bills and emergencies, and in cases where the consumer had no choice of providers. The bill may not impact this program, but we're providing the information to all of the medical and health professions. And under public outreach, we attended the Texas Hearing Aid Association Convention in Houston in June, which is always a good time to go and meet with our licensees. Under personnel updates, Amanda Smith has joined the medical and health professions section as an executive assistant. Amanda has many years of experience in aiding in the regulation of health professions at DSHS. And under medical and health professions section update, like I said, we've been busy since June working on bill implementation teams, which involves helping with draft rule review and fiscal impact forms. We've published 9 issues of the TDLR Health Monitor, which is emailed to our subscribers and available on our website. In your meeting packet, we've included the Senate Bill 202 implementation report on program transfer. This report can be found off of the TDLR webpage under agency reports. Senate Bill 202 transferred 13 licensing programs from DSHS to TDLR, and part of the bill requires TDLR to develop and submit an annual report regarding the implementation of the bill. The report provides a transition overview, a summary of advisory boards and committees. It references the State Auditor's Office audit report, current initiatives, and key statistics. And then finally, in the packet, we also included the State Auditor's Office report. On January 30th, 2019, we were notified of the State Auditor's Office intent to audit the health-related programs that were transferred from DSHS. The audit objective was to determine whether TDLR had processes and related controls to help ensure that the agency administers regulatory activities in accordance with applicable requirements for selected health-related programs. They published the report in August 2019, and overall the audit found that TDLR has developed processes and related controls to administer and regulate the health-related programs as required by statute, administrative rules, and department policies. However, not all processes, controls, and policies were sufficient. They found a few areas where we need to strengthen things. One of those was in facility inspections, which doesn't apply to this, and also penalty matrices, which was not for this program either because your penalty matrix has been in place. Do you all have any questions for me?
I don't. Anybody else?
Nothing?
Thank you very much.
Okay, thanks.
We now hear from Executive Office.
This is David Gonzalez with the Executive Office. I'll be giving the report. Good morning, board members. I'm probably a new face to you guys from this side of the table. I'm usually sitting back there with the agency growth. We've had some changes here at TDLR. I am one of 3 deputy executive directors. We used to have Carla James. You may have met her before she retired in November. When she retired, Brian Francis recognized that with our growth, that maybe he could stand to have some help. He's got some pretty broad shoulders. He's been bearing the brunt of a lot of the work that we do, but he's got some more help now. He hired me from the RPM division. I used to be the division director for RPM. I've actually been with the agency for 23 years, so I'm not new to this process, but just new on this side of the table. He also hired Christina Kaiser, our former enforcement division director, to serve as a deputy director. So he's trying to spread the load, make sure you notice he's not here. His bubbling personality, I'm going to try to fulfill. I'm a cheap substitute. I don't have his same energy, but I'm trying. I'm going to try to do my best to channel Brian when I'm here. We also have Ms. Kaiser, who's moved on to her deputy role. She still oversees enforcement, RPM, which is Regulatory Program Management, and the divisions that she oversees. She had responsibility for enforcement before, but she's taken on a new role with the RPM because that used to belong to me. I've taken over customer service, licensing, and education and examination. Those are all new roles for me, so I'm going to be kind of filling into the job and learning as I go. If there's things that I'm doing wrong, things you need to hear from us, you just let us know. We've got lots of changes happening, so we had to fill our positions. The position I vacated was filled by Charlotte Melder, who used to be one of our section managers in RPM. She became a division director for RPM now, so technical experts she oversees, Heather and Katie and their group, and also Ron Foster, and I love his name. We're going to foster appreciation for Mr. Ron Foster. He took over as the director of our enforcement division. So those are some of the personnel updates we've had. Communication outreach and statistics is something we've started adding so everybody knows what their website traffic is like. Over the past 6 months for hearing instrument fitters and dispensers, you have had 18,023 views with an average of 98 per day for the past 6 months. So that's actually pretty good high traffic. 70% of those visitors accessed your site from a desktop computer, while 27% did so from a smartphone and 3% from a tablet. The top reasons for visiting y'all's page, y'all's site, is exam information, forms, administrative rules, frequently asked questions, and statute. Next on the agenda is the sunset review process. We are currently undergoing sunset. We are fortunate that we had a little bit of a relief from our sunset review schedule because we received so many programs, they decided they'd wait a little while to get to us. Well, it's here now, and in fact, we will be undergoing 2 sunset reviews. The one we're currently under is for all the programs that we received prior to September 2016. That means this program would not be in that sunset review. All the other programs that were received prior to September 2016 would be in the review. We will be undergoing another sunset very soon after this one's done in May of this year for all the programs that came over as part of the transfer from DSHS. So this is an opportunity for us and for the public to give us input. We actually completed our self-evaluation report. It's posted to our website. It's also posted to the Sunset Commission's website, so you can see what we believe we've done and how we do our work. But this report that the Sunset Commission does, it's to determine whether or not our agency is going to continue. It's to determine whether programs are going to continue. This is not typically a kudos and adulations report. They're going to be looking for things that we can do better. They're going to file an exception report, I expect, letting us know where we can improve and how things can get better at TDLR. It's an important time because the public's input on this stuff, in fact, y'all might be contacted if y'all haven't been already, to give us input on what we can be doing better. So I would encourage you, I would encourage the public to track this process, give us input, give the Sunset Commission their feedback, because it is an important time for TDLR, and it's an opportunity for us to grow. We do embrace this process. It is a good thing for us to hear what we can be doing better, and then we take our lead from those things. Last thing is strategic planning process. Another process that allows for public input. We've been doing this for years. I think the way we do it has taken it to a different level compared to maybe some other agencies. We actually go out to the public. We have forums out in different areas of the state. In addition to having the strategic planning process posted on our website, we ask the questions of our public. What are we doing right? We'd like to hear that. Usually we get a few things that we're doing right, and then we ask the questions, what can we do better? What do you see in our future for the next 5 years? We'll ask questions such as, if you were king or queen for a day, what statute, rule would you change? Based on the input we received, we actually put together our strategic plan for the legislative session. So we do these strategic planning processes in between sessions, so we have a plan for the next year. When the legislators ask us, hey, what pain points do you have? What have you heard from the public about how you're performing your job? We use the strategic planning process to let them know this is the feedback we received, and these are the things we're prioritizing based on that. And it's been successful for us so far. Definitely want to encourage, when it comes time to put that information out, like I said, we're going through sunset right now, so there's an opportunity there. The strategic planning process is another process, so keep on our listserv so you get those notifications and can participate in that process as well. And I believe that's all I have for the executive report. Is there any questions for me?
Nope. Thank you very much.
Thank you, sir.
Okay, we'll move to item F, discussion and possible recommendations on proposed amendments to existing rule.
Good morning. I'm Wendy Pello, Assistant General Counsel. This is agenda item F on your agenda. It's very long caption. Basically, we are proposing rule changes to 16 Texas Administrative Code, Chapter 112, which is the rules for the hearing instrument fitters and dispensers program. These changes include proposed amendments, proposed new rules, and proposed repeal of existing rules. Before I get into the substance, do want to note we don't have a quorum today, so we won't be able to get a vote or recommendation from the advisory board, but we did want to take the opportunity to walk through the rules, give you an opportunity to ask questions, have a discussion, but we won't be able to get any recommendations from the advisory board. The department will go ahead and propose the rules without the recommendation, but when we come back after public comment, we can get a formal recommendation with a quorum at the advisory board before moving forward to the commission. Just a little background in terms of, this is a pretty substantive packet of rules, and it contains 4 different areas for change. One is the bill implementation changes. There were 4 bills that we are implementing through rules in our rule chapter, and that's House Bill 1899, House Bill 2059, House Bill 2699, and House Bill 2847, and that includes several sections within that bill. We're also, the proposed rules also are clarifying the amendments and clarifying the submission of the surety bonds and other financial security that's submitted to the department. We're addressing the permit extension requirements in terms of timing, and then the ramifications of what happens if the permit extension is not requested within that time frame. And then we are also making some what we call terminology and other cleanup changes, kind of a catch-all of changes. So in your rule draft, I've set that out just kind of on that first page, kind of an overview of the changes that are in this package. And then for each rule section, I've annotated with a note under that section of this is a bill implementation change or this is a terminology cleanup change. So walk through that. Do you have any questions before I start? Just on page 1, at the bottom, you've got section 112.13 officers. This, under subsection B, we're just doing gender-neutral language. And what I mean by that is changing the his, her, the he, she type language to either say a person or the individual or the licensee. So those are in the cleanup changes, and that change actually ends up on the top of page 2. Keep moving through. Subchapter C, this is page 2. We have 112.20 in there. This is there's no proposed changes to this section. We put this section in here so you could see all of subchapter C, because there have been significant changes to subchapter C regarding the examinations. A lot of this is due to House Bill 2699, which did cleanup changes to the examination requirements under the statute in terms of references to examination and test and eliminating that 70% pass rate that's required by statute. So we've done a lot of cleanup in this. So when you get to page 2, section 112.21, examination contents and administration, we have switched the order of 2 rules, point 21 and point 22. When we updated the terminology from examination to test, it made more sense to have the rules in a different order. It helps with readability. It helps explaining this is what the examination is. The examination consists of these 3 tests, the written, the practical, and the jurisprudence. So that made more sense to talk about what the test was, what the contents were, before you talked about what the qualification process was for an applicant to apply to take the exam. So when you see in these changes, a lot of this is cleanup. It shows up as all new just because we switched the order, so we have to repeal. You can't just change the numbers. When you do the rules, you have to repeal the rule and then propose it again. So it looks like it's all new, but it's not. The changes we've made throughout are cleaning up the references from examination to test to align with the statute. And then we've, under subsection B1, which ends up at the top of page 3, we have removed the specific entity who's administering the written test and replaced it just with a reference to the department's designee. That makes it consistent with all 3 tests. It also allows flexibility if there's future changes to who performs those, who conducts or administers those tests. It's just the department's designee. So that you see those changes at the top of page 3. And then again, subsection C, this is the contents. This is coming out of the statute, and there aren't any changes to that. Do you have any questions on that rule? Moving to page 4, what was the former 112.21 examination qualification? Again, this is been relocated, and so it's all being struck. Page 4, 112.22 examination qualification process. Again, this is one of the rules that was switched in the order. We changed references from examination to test to align with, to implement House Bill 2699. We do want to note the former rule that was moved, 112.21D, it had a reference about moral turpitude. That language was removed from the statute, and so we repealed that also from the rules. The former rules also included 112.21F. This is a provision that was out of place in terms of it didn't apply for this rule, so we've removed that as well. Any changes or questions on that? And then you see on page 5 the old 112.22 being repealed. Jump over to page 6, 112.23. We've changed the title, examination and test results, taken out scores. This is, again, changing references, examination test. This is the place where we check out the reference to the having a score of 70% or greater, because this was removed from the statute, and eliminated references to scores. So this is implementing House Bill 2699. Bottom of page 6, 112.24, the title's there, changing the title. And again, just changing references to examination and test. We broke up what was this former rule was all one paragraph. We broke it up into separate subsections just to address the different concepts about retaking the exam, retaking the part of the practical test that you failed, paying a new fee, and then holding a current temporary training permit license or an out-of-state license to take that exam. So just broke those up since those are a little bit distinct concepts under that rule. Under page 7, 112.25, changed it to practical test proctors from examination proctors, and this aligns with the changes in the statute, changing examination to test, and just changing the title. We just also made a cleanup change down in B3, just lowercase department. Any questions on that? Page 8, 112.26, the jurisprudence tests. We've changed it from a jurisprudence exam to a jurisprudence test, again aligning with the changes to the statute. We've also made some other just terminology and cleanup changes. There we had a lot of cross-references to the practical test under this section. So take that out since we've been really clear about what the practical test, what the written test is. So there's some cleanup there, changing references to the department's third-party provider to the department's designee, so just for consistency in language. And then just for consistency, lowercase jurisprudence exam. Questions? Bottom of page 8, 112.30. Under subsection, you've got, it's kind of a significant note, we've got a variety of changes in this. This is for the hearing instrument fitter and dispenser license, the application and eligibility requirements. You've got, see from the notes, we've got a variety of changes. We've got some terminology and cleanup changes under subsection D in terms of putting in our standardized criminal history language, which references Occupations Code Chapter 51 and 53 in our criminal conviction guidelines. The meat of this section is updating the surety bond requirements and how those are submitted. The current financial security and in most cases surety bonds are located under the current rules under 112.60, And they're requiring the sole proprietor, partnership, corporation, or other legal entity, and just for short, business entity for purposes of our conversation, to submit the surety bond or the other financial security to the department. And it is required by statute that financial security is covering both the business entity and the license holders they employ. So what we're trying to do under this subsection C is explain how the business entity files the surety bond on behalf of itself and the license holders that it has. And so what we've done is having them submit the surety bond, provide it to the license, to the applicant who's applying for the license, and they would submit that with their license application, or the business entity could submit it directly to the department, and we would provide a form so that way we could identify who it's covering, who that bond is covering. The changes with that is changes with House Bill 4007 from 2017 legislative session. It changed the statute to remove the requirement the owners or the partners, general partners of these business entities be licensed hearing instrument fitters and dispensers themselves. So I think in the past, they would submit, when they submitted their license, they were also submitting on behalf of all their license holders. Well, the owners and general partners are no longer required to hold a license themselves, but the business entities are still required to submit the surety bonds. So we're trying to figure out a way to make that connection between the business entity and the license holders, and making sure we know when we receive a surety bond, who is it covering? And so this is kind of part of a bigger project, also working with our IT department in terms of making that connection. So this is where our proposed changes in this section is in terms of when you're down at the page, bottom page 9, that subsection C. This is, we're saying the applicant's employer who is subject to 112.60, and it sets out that sole proprietor, that list of business entities. They either have to provide it to the license holder to submit with their application, or they can, in the alternative, they can submit it to us as well. And it has to be received before we issue.
Can I ask a
the
question?
license. Absolutely.
Richard Davila, this form, will it, when you're covering employees, will the form reference the employee, where they're employed, and what happens if they leave employment?
Right, and we have a rule later on about the changes of employment, and I don't think
And it covers
form-
the 30-day, you've got to submit within 30
right.
days, which
And
I read.
but you raised a good, the form, I'm not sure if RPM is in development, but that's part of our plan, because we do get surety bonds right now from licensing, receive surety bonds, but it's the company name, but we're not sure, since we don't license companies, who it's tied to, who it covers, so we do want to develop a form that would identify the license holders and got Katie coming, reinforcements.
Katie Bryce with RPM. So currently, the form still has outdated language of DSHS on it, and so we need to update it to TDLR. And it doesn't have any place on it to list the licensee's name who's being covered by the surety bond. So the surety bond will not list the actual licensee's name. It'll still be the employer, but there will be like a cover page where the employer can list the licensees who are covered under it. That way, the surety bond stays in effect, but as people come and go, they just need to provide an updated one with their new employer. Does that make sense?
Yeah, is there a time frame you think this will take place?
I think we're wanting it to be done upon renewal, just so that everybody has an updated form referencing TDLR. But Wendy will get to that later in the rules, I think.
Okay, thank you.
Yes, for the new applicants, for this rule, this would take effect, and so applicants would be submitted immediately. For the renewal, when we get to it later, we were going to have it be for the first renewal on or after September 1st, 2020, and that way we have an updated surety bond, as Katie mentioned. When the program transferred to TDLR, the companies and the license holder didn't submit new financial security, and so we've got financial security that still has the former licensing agency named. So we've updated the form, and I think RPM at past meetings has updated, let you know there's a new surety bond form. I think licensing's let you know in past meetings with that RFI requests for information have gone out in terms of, hey, you've got the outdated form. But this, what Katie's talking about, whether it be a cover letter or a separate form, somehow you can identify the license holders, because the surety bond itself is with the business entity, and it's made payable to the department on behalf of, for the reason set out in the statute, on behalf of those license holders, or on behalf of the consumers who would make a claim. And then the other party to that surety bond is the surety bond company. But the license holders are not named there. So this is a way, whether it be a cover letter or a separate form, for the company to identify who its license holders are.
That hadn't been developed yet, the form?
No, not that I'm aware of. But that'll be part of our bill implementation team. That was our development in terms of doing this rule. And that's, we put in the rule that they must submit the prescribed form. So before this goes into effect, we'll obviously have a form ready for business entities to use. So that's kind of our take on, for the initial application, it'd come in for the application. And we wanted to give the flexibility in terms of, there are options for the different forms of financial security that the business entity could use. So if they felt more comfortable submitting it directly to the department and with a list versus to each license holder, they could do that as well. Other questions on?
Richard Davila again. There are a surety bond, but then there's listed other forms of financial
Right.
security. What section are they in?
They're back in 112.60. Those are the existing rules. And so that's where we're trying to make a connection between the business entity submitting it, but we don't license them. How do we make that connection? What's the best or the easiest way to get that information?
That makes sense.
So, but this gives a little flexibility in that. The other change in this section is subsection G, and this is, we're implementing House Bill 1899, Section 8. And this shows up. This shows up near the bottom of page 9. It's kind of right, sorry. Nope, sorry. Page 10, subsection G. The commission, the department shall deny an application pursuant to Texas Occupation Code, chapter, or section 108.152. This is a new law that applies to certain healthcare providers, and hearing instrument fitters and dispensers is one that is listed in the bill, and this is an automatic denial or revocation of a license for a person who's been convicted of certain crimes or has been required to register as a sex offender. And so there's no discretion for the department in this, but we want to put you on notice, applicants and licensees, that this is a requirement. And it's separate from your enabling statute, your program statute. But this is another reason for denial or revocation. And it's, the department's involved, so I think it's important to have it here for everybody's notice as well. So that's the other, so there's a lot of changes in that section. 112.32, this is the hearing instrument fitter and dispenser license term and renewals. This is page 10. Again, we have a lot of notes here. This is subsection D, inserting the standardized criminal history background check language. We also want to note under subsection D, and the actual text shows up on page 11, we've changed and updated the language to say that the license holder will not have to submit new fingerprints or renewal to the department. Will notify the license holder if they need to. We've found a few instances, problems with fingerprints, that there may be a reason to go back. Also, when they do fingerprints, we subscribe to a wrap. It's called a wrap back, and basically it looks back and it's always searching. Apparently that wasn't always checked previously, and so that's, make sure we've got that, so we may not have updated information. That should be very rare. They've licensing's caught this, and so this is just to put folks on notice. There may be, if there's a reason, we'll let you know, but otherwise you would not need to submit new fingerprints at renewal.
Are we on page 11 still?
Yes.
Lance Brooks, I had a quick question if I could.
Yes.
I was just looking, a couple of questions. One, it says that a license holder produces measurement and the testing of hearing acuity. What if those folks work in multiple offices? Does that individual need to submit the documentation for every piece of equipment they use? Or, I was just curious of that. It was item number 4.
C4. Yeah, we weren't proposing any changes to that. I may ask if either licensing and RPM could reduce a measure.
Yeah, I think all is the key word in C4.
That all equipment. Yeah, all equipment that's used by the license holder. It doesn't make any distinction between.
Because I don't think people have provided that in the past, and so I was just trying to think through that. If you have people going to multiple places, is that gonna be you're gonna submit that online when you renew your license? So the calibrations for each piece of equipment, or just trying to think through that.
This is Katie Bryce. Currently, you are supposed to submit a certificate of calibration upon renewal, I believe if you're selected for audit.
Okay.
It comes in with your continuing education certificates, and it's never come up before that there might be, if you're working in 4 different offices, you're using 4 different audiometers. So that may be something we need to address. I don't know if we can do it in this rule package, but in the future for cleanup.
Okay, I was just curious, and I've gone through the audit before. I didn't remember, I know we always have all of our equipment calibrated every year, but I didn't, in the annual renewal, I didn't think there was a calibration submission, but maybe just the audit.
Right.
Yes, Richard Davila, when audited, all equipment used by the licensee, if there are, I interpret it as if there's 10 different audiometers used, and
Then you
submit
should
all
put
10.
in, right. That's the way the rule is written, so.
Thank you.
Thank you, Katie. Subsection, page 11, subsection E, this is we had touched on this a little earlier with subsection E. This is at the renewal, and so we're saying at the first renewal on or after September 1st, 2020, the license holder will submit updated financial security. That's to make sure we've got updated surety bonds. Normally surety bonds and our surety bond form, our template form, provides that those bonds continue in effect until canceled, and then we get 30 days notice before cancellation. So those bonds could have been in effect for many years. So this way ensures we've got updated surety bonds that are payable to the department versus the former licensing board. This also staggers it out so we don't end up with all the forms at once. And again, this.
I have a question.
Yes.
For a person that's licensed, carries a license, but is not practicing, is there a provision that they're not required to carry surety bond for renewal? Or calibration?
That, I would have to think about that. I don't,
Here
there's,
comes Katie.
Getting her there.
Sorry, Katie. Thank you for walking up there.
Katie Bryce, if somebody is not working, I believe licensing accepts a letter that they are not working and therefore do not have an audiometer that they are using in place of that.
So that takes care of not having a bond, not having an audiometer, any of that, the letter.
I'd be
That's,
reluctant to answer that at this point. That's a good question. I think we can go back and look at that. I'd rather make sure we look at the statute and rules closely on that versus trying to give you an answer. That's not anything in terms of what we've changed in the rules. We haven't proposed any changes to what might be the current. But I can mark that to look at that issue, to make sure whether our rules are clear on that issue or not. Again, but bottom page 11, just with that renewal requirements. And again, gives them the option with the license holder or the license holder's employer who's subject to 112.60 to submit that. At the top of page 12, the new subsection F. This says that this is implementing House Bill 2059. House Bill 2059 is a bill that the legislature passed. It's about human trafficking prevention training. This is not targeted to your profession. This bill was drafted broadly and applies to healthcare professionals, healthcare practitioners under Title III of the Occupations Code, which is a very long list of healthcare professionals, those professionals who provide direct patient care. So for TDLR, that affects 10 of our health professions, but it's other professions and other licensing agencies.
Question real quick.
Yes, sir.
Is there a list available? Liz?
We can provide you, it's under Title III of the Occupations Code, but that's something we could provide you with. It's listed in the statute. So you've got, doctors, nurses, TDLR's programs, they come under different licensing occupations, so you're not the only ones. One of the requirements is, as a condition of renewal, a condition of license renewal, you have to complete a human trafficking prevention training as required under this new statute. It's Chapter 116 of the Occupations Code, and then provide proof of completion as prescribed by the department. The Health and Human Services Commission, HSC, is charged with developing those courses, or developing the criteria for those courses and approving courses and making sure at least one of those courses is free. They'll post those available courses on their website. They have a human trafficking prevention training webpage where courses will be listed once they've approved them. Their website also says that they are in the process of adopting or creating their own course as well. So that list will be available up there. Again, one of those courses will be free. They're responsible for doing that. Our understanding is they're in a process of developing rules and developing those courses, or what those criteria for those courses will be. So right now it's kind of early in this process in terms of what those courses will be, how long they will be. Will they be online, in person? Who will offer? How many will be available? Although one of them will be 1 hour. And so we've written this to put our licensee on notice, because this isn't, again, in a statute, not in Chapter 402, the Hearing Instrument Fitters and Dispensers program statute. It's another statute, but this is a condition of license renewal. And bill is written such there's not any language or any limitations that it says this only must be taken once, or it's only on your first renewal on or after September 1st, 2020. So it's a conditional license renewal, and so that's why we have written the rule such that for each license renewal on or after September 1st, 2020, you have to complete that course. And what that course, if you have a certificate or a number, or what that'll look like, that's still being worked out, and so we've left it broadly to provide proof as prescribed by the department.
Richard Davila, leaving it, since there's no criteria, time, the length of the program could be 3 hours long, could be 30 minutes long. We're not sure, right?
That is correct.
But we are sure with this rule that the criteria will be for every renewal after 2020.
Right.
So every 2 years, you will take, we're setting some of the criteria here, with it being, once you've taken it, or you have to take it every 2 years. This is every 2 years.
This is every 2 years, and this is because of the way the statute is written. And the bill it's a condition of license renewal. So it's not a condition of your first renewal. It's not a condition of the first renewal on or after the effective date of the bill or the effective date of the act. And so it's a condition of renewal for the license. HSC, again, will be responsible for putting out rules, but in our preliminary conversations, their understanding is the same as our understanding, that this is not a one-time requirement.
Okay.
Could it not be interpreted like fingerprinting or jurisprudence? That you do it, you complete it, and you have done a training program for your next renewal, which also counts for the next renewal, so on and so forth.
That is not the department's reading of the statute and reading of the bill. The section is in the bill, and it says training required for license renewal. A healthcare practitioner other than a physician or nurse shall successfully complete a training course described by section 116.002 as a condition for renewal of a license issued to the healthcare practitioner under this title.
It's clear.
I said there's not any restriction if it's a one-time course or take it for your first renewal after the effective date. It's a condition. So each time you come for a license renewal, it's a condition. So it's something we can obviously provide more information as we get more information and links to the HCC website. and what that is, but we do know one of those be free. And again, this is a statute, outside of our statute, we're wanting to make sure our licensees know that this is a condition of renewal, that it's not bound if you went to your Chapter 402, that this is a new requirement. Again, it's affects quite a few different healthcare practitioners.
Is Health and Human Services have a target date for development of the materials?
Their website was saying that they wanted to have courses by summertime. I checked it before, so, right, we're putting you on notice of now, but they understand that no one has to take, the bill states that no one's required to take this prevention training course before September 1st, 2020, but they recognize that there's healthcare practitioners that will need to take it for renewals on or after that date, so.
It's an interesting time frame.
So I recognize this type, we want to get that in the rules and make sure you all have notice of that. As we have more information, we can provide that as well. So that's what that requirement is under subsection F. Subsection G, we have combined what was E and F and removed that language and just consolidated that into G and did the cross references to the statute for this exceptions to renewal. Any questions? Page 12, 112.33, application by license holder from another state. The types of provisions that we put in under point 30 for the initial application. Similar provisions are here. Changing references for examination to test, inserting the standardized criminal history language, subsection D. Again, having new subsection G implementing House Bill 1899, which is that automatic denial or revocation of the license for certain crimes. And then again, adding subsection H, which is clarifying the requirements for submitting that surety bond and explaining how they would file it. And again, it gives the option of whether it's the individual, the business entity giving the surety bond or other financial security to the applicant to provide with their license application, or they provide it to us directly. So you've got a lot of explanations. So you see it, a lot of the substantive changes are on page 14 of your draft.
Richard Davila,
Yes.
let me ask one question going back on continuing education. Will we be utilizing whatever the time frame length of that class, continuing education class, or medical ethics, professional responsibility class for anti-human trafficking? Will we be able to use that towards continuing education requirements for the program?
That'll be our discussion in agenda item G. Right now, it's the short answer, it's not being counted towards your continuing education hours. Right now, it's a standalone, separate renewal requirement. But when we get to item G, that's where we'll have kind of that discussion about that course in continuing education.
Okay.
So we can delay responding to your question, but that we will discuss that. But right now, it's just a standalone renewal requirement. It's not part or counted as any of your CE. Okay, so any questions on point 33? Starting at the bottom, page 14, this is the apprentice permit, application eligibility requirements, section 112.40. We've updated references from examination to test to align with House Bill 2699, the statute. That's under C4 and C5 under subsection D. We just updated to include the standardized criminal history background check language. Page 15, 112.42, apprentice permit term and extension. This was brought to our attention. The current rules, the way, let me back up. The proposed rules are basically specifying the time frame of when someone can submit an extension request to extend their permit. And this is same for both the apprentices and the temporary training permits holders. So you'll see on page 16B1, you need to submit your request on a department-approved form not later than 90 days after the expiration of your permit. And then when you see under the new subsection E, It kind of sets out the ramifications. So you have 90 days from expired to submit that request, and after that, the date, the person must apply for a temporary training permit and to complete that again, and then also do the apprentice permit. That is what is currently happening, how the rules are, because there's not an extension request once your license expires, or once your permit expires. There's not it's not a renewal, so it's not a late renewal or charge a late renewal fee. So it's expired, so it means you have to start over. Well, if you're starting over at the apprentice level, to apply for a new apprentice permit, you actually have to hold a current temporary training permit. So if you've got an expired apprentice permit, you've got a very expired temporary training permit, which means you need to start the whole process over. We've ended up having a couple of these a year between the apprentice and the temporary training permit. So we want to make sure there's an extension time period, but that's not too far out, that because this is part of training, that you don't want the time frame to lapse too much before they would continue that with the permit. So that's what we've set up, a 90-day grace period to submit the request. Hopefully people would submit it before, but you've got 90 days to do that. And then it sets out clearly what happens if you don't meet that time frame. So it's clear to everyone. Any questions or?
Any questions?
Okay. Page 16, 112.50. This is not, again, one of those, this is a reference section. It's not, there's not any changes to this. We want to just include this when we get in reference to changes made to 112.52. So if you flip to bottom of page 17, 112.52, temporary training permit term and extension. We've made the same change here for the extension of the temporary training permit, specifying that they have to submit the extension request not later than 90 days after the expiration of the permit. And then under subsection E, setting out kind of what the consequences are of having to start that over. And with temporary training permits, if you're starting that over, that's going to count as your second permit. Because back up in 150, you can get your permit twice. So that just put people on notice that that's going to count as your second permit, if they have to do that. Any questions on that? Page 18, 112.53, temporary training permit, supervision, temporary training requirements. This is just an example of under subsection C using gender neutral language, and this is right at the bottom of page 118, changing the his, her to the persons. One of the things with Sunset Review, they're always making sure we use gender neutral language. As Mr. Gonzalez stated, that this program's not under Sunset Review, but as we're looking at all our programs, we make sure we're just go ahead and making all those changes. So we're making those changes in our rules. Jump to, this is a big jump, there's a lot of existing text that's not being changed. Jump to page 20, subchapter G, financial security requirements. This is section 112.60. This is where your existing financial security and surety bond requirements are. And so this is what we're clarifying, how to make that connection between the business entity and this. As I mentioned earlier, House Bill 4007 said that the owners and the partners no longer had to hold the license themselves, but that business entity is still doing the surety bond. So what we've done is the other thing we wanted to make very clear is that bond is not just for the business entity, it's for the license holder employees. So we've added clarifying language under subsection B. Under D, we've identified the 3 times that the business entity needs to file. We've already talked about 2 of them. At the initial application, at that first renewal on or after September 1st, 2020, and the third one will show up in a couple rules is when there's a change in employment. So we've just tried to put them on notice of this is when we need to get it. There's a reference in terms of that we need to have the surety bond information before the license is issued, and we've clarified it's the employee's license, since we don't issue a license to a business entity. So that's where you see those changes. So when you turn to page 21, we've clarified under B, it's what it's covering.
Can I ask a quick question?
Yes.
just thinking in the past, if you could, in order to be in this business, you had to be licensed. If the rules are changed that you no longer have to be licensed to own the business, and if that business then submits the bond, are you going to create a different entity number for that business? Or is it just strictly going to be, if the business submits the list, then that'll just be a portion to each individual dispenser? I was just curious, because then it kind of changes the ballgame if the owner of the business no longer has to be licensed, but then they're submitting a sheet on behalf of the business. I was just curious how you're going to track that.
That's what we're working on. That's what we were talking about, either having a cover letter or a separate form that we would track that. That's part of our IT division's trying to figure out how to make that connection. That change is not due to our rules. There was a change from the 2017 session, House Bill 4007, that removed that requirement on the owners and the general partners of those businesses for them themselves to hold the hearing instrument fitter and dispenser license. Now, if they're practicing and engaged in that, they would need to, but just being an owner. But that was a change from the statute.
Okay.
And so these rules are catching up, and how do you make that connection? If it's not necessarily your business owner, your CEO that's submitting it, how do you make that, and they're not holding the license, how do you make that connection? Because they're still, the business entity itself is still required to submit the surety bond, and it's covering their actions and the actions of their employed license holders.
It just almost seems like that entity is going to have to be in your database.
And that's what we're trying to do. That was having that discussion of having the business entities, but do we have all that list? And so that's what we're trying to make that connection, and having it come through, whether it be the license holders themselves, having that submitted with their applications. So we've made that. We've just done a cleanup language. Mr. Davila, you had talked about the other forms, and that's on subsection C in terms of the other forms of financial security. It's the surety bond, the deposit of cash, certificate of deposit, or a letter of credit. And again, that financial security is $10,000. It's not $10,000 per employee. It's $10,000 for that entity. And then again, starting at the bottom of page 21 and 22 is just listing those 3 times when we need to file that, and then just clean up of language. Any other questions on that? 112.61, recovery on surety bond, other form of financial security. This is something unusual. We usually will eliminate language and just cross-reference back to the statute. In this case, we thought we had the cross-reference to the statute. We thought it was important to bring the concept that's in the statute, and what I'm talking about is section 402.405, which is listing the reasons and what it's covering and who it's covering for the action. So this is, when you see under subsection A, the list of, misstatements, failures, various failures.
That's directly from the statute.
That's
right?
directly from the statute. But when you look through that, you can see some of these are for the business entities, some of these are for the license holders' actions. And so that's why we wanted to make sure that was really clear to everyone and bring that into the statute.
Can I ask,
Into the rules.
can I ask a question there?
Yes.
It says, is there a time frame on that? Is that the 30-day trial period? Or the reason I ask, I was looking at number 3, the diagnosis of a medical condition unknown to the purchaser at the time of the purchase. It's kind of resonates with me because I had someone walk in the other day, had hearing aids for is either 10 or 12 years, and they said, well, this is warranted for life, right? It's like, no, the purchase agreement specified how many years. So if you got a diagnosis of a medical condition, you purchased the hearing aid 3 years ago, and then you get a diagnosis of a medical condition 3 years later, is that applicable? I was just trying to understand the time frame of this. Does that make sense?
Yeah, I mean, this is right out of the statute.
It's been in place.
Yeah, it's showing it new in the rule, but we just mirrored it of the statute to bring that out of the statute.
Well, and again, I'm sorry if I'm being daft there, but I was just thinking, so if I buy hearing aids 3 years ago, and then I'm diagnosed, I've got a patient right now that can't put anything in her ears, but if she bought hearing aids 3 years ago and that becomes a recent condition, is she eligible to recover that money?
Well, I wouldn't want to provide any legal advice on that, on a particular situation. I mean, if we can look at that if that's an area of,
I was just.
first,
again,
this,
I was just-
right out of the statute, so if there's things we can do in rule to clarify that or tie that, we can look at that. I wouldn't offer
I was just
advice on any
thinking, what's the
particular.
timeframe legally?
Okay.
Is it 30 days? Is it a year? Is it 3 years?
That I don't want to answer off the top of my head on it, and that's just one other area we can to look at and go back and look at statute and rules.
David Gonzalez, TDR. That's what this public comment period is going to be for these rules. This is a substantial package. Obviously, there's a lot to go through, and y'all have already pointed out some of the items that we're probably going to get some comments on, so this is the opportunity for us to get that feedback. But I definitely appreciate the questions that are being raised here. Some of the questions that have been most significant are the ones on existing language, which concerns me a little bit more because
Right.
we've got a rule package on the things we thought we were working on, but it is an opportunity.
Well, and I would go on to say that I'm very complimentary of TDLR and Mr. Francis, and they're very impressed with them. Sometimes in the past, prior to TDLR, you could have a question like this and call and not get a great answer, or feel like you didn't know more than when you called. And so I think I applaud that. And I just was trying to understand as I look at some of this and go, there are people these days, and I don't have anybody that's upset with me, don't misunderstand me, but that I know of anyway. But, we do see people looking for language that is ambiguous so that they can say, well, at the time, I didn't have a diagnosis. Now I do. Again, I brought up the thing about the person that walked in, his purchase agreement clearly said it was a 2-year warranty, but at 10 years, he said, I think it's unreasonable that you won't repair this hearing aid without a repair charge. And I'm thinking, so I just wish we could look at it.
David Gonzalez, TDLR, definitely understand, and I don't think we have a better answer right now than maybe DSH has had at the time on these matters. If there's something we can do by rule, we can explore that, but if it's statute, we may be where we're at continually.
Okay, excuse me, thank you.
Thank you, David. Any other questions on that section? Page 23, section 112.71, continuing education records and audits. Got a lot of text, but just under subsections A and C again, replacing existing language with gender neutral language, replacing the his, her to the license holder. A and C. Page 24, 112.91, change of name, address, or other information. This used to be just what was under, looks like new subsection A. It was just a standalone provision about it said the licensee, which is defined under our rules to be the license holder and the permit holder. We've just clarified it here because when we add subsection B, we're only talking about the license holder. So subsection B or subsection A, sorry, has the current requirement within 30 days to notify the department of changes of name, address, telephone number, or employment. And this is where we've added the new subsection B. If the license holder changes employment, the financial security on file with the department must be updated. And that can be from their new employer through the licensee, or when they submit their notice of change of employment, or again, the employer can send it directly to. So this is the third instance when the department would receive financial security. Questions? Bottom of page 24, 112.98 Code of Ethics. Again, subsection C and D using gender neutral language, and then just a cleanup change in subsection D as well, removing the and or to or. Easy changes. Page 26, these are the fees under 112.110. This is changing under subsection E the references from the examination to the test. And now, instead of the references examination, it's written test, practical test, and jurisprudence test. Page 27, 112.111, 120 complaints. This is subsection M. Right now, it's complaints, and I think it just has one rule, one section. We are combining subchapter M and subchapter N, which is the enforcement provisions. Those are two related subject matters with the complaints and enforcement provisions, so we are combining those into one subchapter, so that you see the change in the title of subchapter M under point 120 complaints, just because now we've added some additional provisions regarding complaints. These, the new subsection B and C are a result of House Bill 2847. What's under new subsection B is there was provisions allowing that a person can assist the department in the review of an investigation of complaints, and they would be immune from liability. This might be in cases where you've got a scope of practice, standard of care. We need experts that this will allow, and hopefully encourage either it be advisory boards or other license holders or other qualified persons to feel comfortable assisting the department in that review. So subsection B is this provision was not put into the into each of the health programs statute. It was put in our Chapter 51. So we just wanted to let you, as a notice, that it's over in the Department that Commissions Enabling Statute, which is Occupations Code Chapter 51. Under subsection C, this is regarding the confidentiality of complaint and disciplinary information. The health programs, when they are transferred from the Department of State Health Services, each of them in their own statute had a confidentiality provision about disciplinary action and handling protected health information. House Bill 2847 removed that from the individual statutes and put a one unified statute, a uniform provision, and again in our Chapter 51. And it also enhanced and updated those provisions. So this again is directing you back to Chapter 51, so you don't think you've lost your complaint or your confidentiality provisions regarding disciplinary actions or complaint information. It's over in 51. Any questions? What's at the bottom of page 27, 112.121, administrative penalties and sanctions. This was former section 112.130. It was over in subchapter N. It looks like all new because it's, we've moved it, but there are no proposed changes to the text. Page 28, the same with section 112.122, enforcement authority. This was former .131, no proposed changes to the text. 112.123, refund for hearing instruments, former section 130.132, again, no proposed changes. Under 112.124, surrender of the license or permit, we've updated subsections A and B that we've again relocated to have gender neutral language. And then again, we've added a subsection D to clarify that new requirement is required by House Bill 1899 that you can't surrender it if there's an automatic denial or revocation. You can't surrender to avoid that. So that's what the new subsection D is, that this section doesn't apply in those situations. Page 29, 112.125. This is the automatic denials and revocations as a result of House Bill 1899. And this is just saying the department shall deny the application or revoke for those conditions set out in this separate statute under Occupations Code 108, subchapter B. And then that same chapter sets out how someone could be reinstated with their license, and again directs them over there. So we don't bring over everything out of that statute, but we do put you on notice, the licensees and the applicants on notice that there's this separate requirement. And then the remaining bit of the rules is subchapter N, enforcement provisions, and those are all being repealed because they've been relocated.
Wendy, Richard Davila, in House Bill 2847, I think it's Article, you referenced 7003. We have a reference to the department can qualified people to assist is in E, but just prior to that, it says the department may accept but is not required to investigate a complaint that lacks sufficient information to identify the source or the name of the person who filed the complaint. Is that new for anonymous complaints?
I'm sorry, where are you reading?
House Bill 2847. Sorry. It's in section 7003. page 19 of that.
Where it says
House
the
bill.
department, subsection,
B1,
yeah, it's section 7.003, the bill, and ends up being sections 51.252 of the Occupations Code, which is our enabling statute.
Yep,
There's a
and
new,
then,
new
well,
B1.
the next page, yeah, B1.
The department may accept, but it's not required to investigate a complaint that lacks sufficient information to identify the source, the name of the person who filed.
Is that new language for anonymous complaints, like where you're not required to investigate? I guess you could.
It's new language in the statute. I don't know if anyone from enforcement here can address in terms of current practice. Well, if it's lacking sufficient evidence to identify this.
Yeah, an anonymous complaint.
This is David Gonzalez with TDLR. It's my recollection that TDLR does accept anonymous complaints at this time for most of our programs. However, it is if it's limited information, it's difficult to do follow-up. As Wendy was pointing out, that appears to be new language in this particular statute that addresses it.
Yeah, as they said, I'm Karen Cox with I'm senior prosecutor. Sorry, it took me a minute to get up here. We can accept anonymous complaints, and sometimes we do. This just gives us the option of determining that there isn't enough.
And you can't reach out
We
to
can't
anybody.
reach out to anybody.
I see, okay.
And also, this provision is universal in all of our other programs as well now.
Sure, I just want to understand how it applies to this program, which is
Okay.
either or. I mean,
It-
got it,
yeah.
makes sense.
Thank you, Karen.
Thanks. Thank you, Karen. Yeah, having it be in Chapter 51 will now then have that be the same across our programs. So that'll standardize what that complaint process is about anonymous complaints across programs, since it's in our Chapter 51. Any other questions or on those rules? Okay. Again, since you don't have a quorum, we won't be able to take a vote or final recommendation, but obviously, you're all free to make public comments, and the rules will come back to the advisory board with public comments for a second round of discussion as well before it goes to the commission, get a recommendation.
Good?
I
Any
think that's it.
questions?
Do you have any other questions
more
on
questions?
subject, or on our agenda item F?
Okay. I guess you're going to continue to sit there. We're going to move to item G.
He's on the hook.
Okay.
Thank you.
Yeah,
And when-
so now we're going to discuss House Bill 2059.
Yes, again, Wendy Pell, Assistant General Counsel, this is agenda item G, discussing House Bill 2059. The agenda item also has possible assignment to an existing work group or appointment to a new work group. Because you don't have a quorum today, we won't be able to do that, but we can have discussion, kind of lay out the issues, and at your next meeting, when you do have a quorum, you could take that next step with appointing to a work group. This issue, Mr. Davila raised a little bit earlier when we were having the rule conversation. Again, House Bill 2059 is the requirement that you have, you take a human trafficking prevention training course as a condition of license renewal. As you saw in our rules right now, it's just a separate standalone renewal requirement. This agenda item is having the discussion of whether that course could or would or should count towards continuing education. Our executive director asked for each of the advisory boards for the Affected Health Program to have this discussion and obviously have a work group to discuss the issues about whether they could count that human trafficking towards their continuing education. And I say could is with your statutes, your rules, any national accrediting association that may be tied to that particular profession's continuing education, would that be possible? If it was possible, would you want that human trafficking prevention training to count towards some of your CE? If you would, what would that look like? How many hours would it be? Would it substitute for something? Would it be a new requirement? So there's a variety of issues to work through that. The department, because there's a lot of issues and there's some complicated issues, and I think it may look different across professions, would be recommended to have it go to a work group to kind of drill down and have that work group look at the issues, but that you'd also be working with TDLR staff, probably from a variety of divisions, to kind of look at those issues. So kind of open that up for discussion or questions.
Well, Ben Norris, earlier you were going through and I think you made a comment that they, talked about they're going to develop a course that is free of charge. And in that conversation, I swear I heard you said an hour long. Did you say that? Or would you saying you don't know if it's an hour long or longer?
There have been talks with some of those courses. I think there's a course at the federal level that they may be approved that is an hour. I don't recall what
Okay,
that
so
hour,
you
what
don't
that may
know for
be,
sure how
what
long
that
the
may,
course
it may,
is.
whether it may be an hour or maybe longer. They're also going to approve courses, so if somebody wants to offer a course and it's 2 hours, it's going to be up to that, provider who wants to offer or provide that training course. The HSC is charged with setting out the criteria of what would be an acceptable course and approving those courses.
Okay, is there any time frame, do we know, from HHSC, right? When those they're gonna come up with the program?
Their website currently says that their goal is to have courses by summer. Hopefully, as I said, we get more information. This is, I said it's kind of a work in progress and it's early on to what that may be. So again, right now, the rules have it just be a straight up renewal. So this may be, we're not expecting this change or whatever, this would not be part of the current rules. If it was going forward, would we, would this board, would this profession want this to count? And I think that's part of the work group's discussion, is gathering information, and it may be contingent, it may be delayed a little bit, wait in terms of the information agency can provide us in terms of what they've approved with these type of courses. Would you find them acceptable to replace or be in addition to existing continuing education requirements for this profession as well? So it's I understand it's a little up in the air in terms of how many hours would be, what they may look at, what they may look like.
Okay, in our existing program right now in jurisprudence test, who set that up? Was it TDLR that set that up, that we could go online, do jurisprudence test?
I don't know if we have anyone for Eni who can talk about that. It's jurisprudence test is required by statute and rules what that looks like. Turn
Yeah,
it
I
over to
understand.
Eni.
I was just curious if a program like HS, I'm gonna mess it up here, HHSC could set it up like that. The way you go online and you.
Right, and that may be one of the,
complete
the
course.
possibilities they're looking at, whether, like I said, it's, whether that's going to be an online course, whether this will be in-person courses, it'll be a variety. So they said we don't have a lot of information right now, and so this is more kind of a long-term project of what that may be and whether they'd be included as CE. But again, we don't have any control over, and I don't know if you need information about the jurisprudence exam.
No, I was just curious because we have that's in place now, and it sounds like this would be, if it was set up the same way, would.
Okay, Gary Hahn. With jurisprudence, it's a one-time deal. This is going to be recurring with each renewal, correct?
Correct.
So I would say it should be part of a continuing education then. If it's part of our requirements, it's in our rules, and it is recurring every 2 years, I think there should be a standard there of, where continuing education would come into play. With jurisprudence, it's a one-time thing. It's done out of our way.
Right, and I think that's what we anticipate the work group kind of looking at that issue and looking at statute and rules in terms of what the requirements are for each program. May have different, statutory rule requirements on the continuing education, who can be a provider, how those providers get approved, if they're approved at all, how that looks. And so I think that's why I want to kind of have that work group and kind of work through all those issues.
I think one of the challenges that I see is if it were be an hour once every 2 years, that would have one implication. If it turns out to be 8 hours every 2 years. To me, the 10 hours per year, in my opinion, I think it's good that dispensers are investing time in learning about their profession and remaining current on technology and reminding themselves of that which they need to do. So if it was a 1 hour, to me it would be one issue. If it ends up being significantly more than that, and that takes away from the requirement for the 10 hours a year or 20 hours per renewal period, that's a whole different bailiwick, if you will. And so I think I think we'd need a clearer picture on that.
Right.
Because I would certainly hate for it to be 8 hours, and I think it's a horrible thing that's happening to people, and it is it's good that people are identifying that we need to do everything we can to stop people being enslaved in that. At the same time, I think if you talk about continuing ed, you need to know what it is we're replacing, or is this just in addition to that, to me, for that discussion to happen.
Right, right, and we recognize and understand, there's a lot of unknowns at this point, and so I think this will be kind of a longer-term project. When we have more information and more details, we'll definitely share that with you, and whether those courses, even if they're longer courses, even if would the work group recommend, okay, we'll give you X amount of credit, even if you took an 8-hour course, would it be 1 hour? So I think that'll be all part of those discussions to kind of delve into.
With the federal program you were mentioning, do you know the length of it or anything about it?
I don't know the details. All of it, I think it was about an hour, but that's for some of the other health professions who already have other licensing boards, so we'll be able to provide you some more information once we get where it's a little bit in limbo right now.
I think there's a lot of unknowns.
There are.
The thing I was looking at, just kind of going, looking at our rules, 11272 G1 or G says each continuing education course will be evaluated by the department on the basis of the following criteria. And number one is relevance of subject matter to increase the support the development of skills and competency in the fitting, dispensing of hearing instruments. I don't think that meets that criteria, number one, so that's something we'd have to look at that rule.
Yeah, and
follow
that's,
me?
I'm sorry.
Well, no, I was just pointing that out when I read it.
Right, I think that's what that first part of that, when I was talking about what the worker needs, like, could you do it? And that first, could you do it, is, did the statute rules allow
you to.
any ties to any other associations or ties to credentialing agencies for a particular profession? Could you do it? And if you could do it, then you kind of get to that next step of, would you want to do it, and what would that look like? So we have a more in-depth, so bring that. We won't be able, like I said, be able to appoint a work group today on that, but it's not a pressing matter, just we do have unknown, so maybe at a future meeting when you have a work group, we might have additional information that would be helpful for that study.
This is David Gonzalez with TDLR. Yes, the work group, whoever decides to be on it, is going to have to listen to this meeting to make sure they don't forget some of the points, because you all have raised some good points.
Okay, so I think it's something for me personally, I'd like to get more information about the program and what they're going to require and how long it's going to be and all that stuff.
Okay, great.
Any other discussion on this? Like I said, we can't take any action right now.
Right.
So,
We can put it on an agenda for a future meeting.
yeah, and that'll be. Okay.
All right, thank you.
Hey, thank you. Okay, so item H we can't do today. I guess recommendations for agenda items for next meeting.
This is David Gonzalez. We'll definitely be putting the rules that we received feedback on back up, so that'll definitely be an agenda item. Appointing work groups can go back on there because we need to have those discussions. So those two items for definitely will be on there. Specifically G. Any other items that y'all care to, y'all can always send us an email to advisory work groups, and if there's something we need to get on there at the presiding officer's discretion.
Okay, any discussion on dates and time of the next board meeting?
The team has, Mary Winston, TDLR, discussed it with Wendy, and we would like to poll everyone, not set a date today. Unfortunately, we typically have a quorum. Unfortunately, we did not today. But we want to best ensure we can get that next time. You all have put out some great conversation for whoever you're going to appoint to that work group. Some food for thought. So if you would allow us to just poll individually later so we can get a date. Okay.
Okay, meeting adjourned.